So at the beginning of January, the Supreme Court will hear two cases that will help to bring an end to the ATF's current overreach and their attacks on the Second Amendment. But real quick before we jump into this video, if you think the ATF's overreach needs to be stopped by the Supreme Court, go ahead and hit that like button and subscribe. So as I mentioned in the intro, in this video, we're going to be discussing two important cases which the Supreme Court will hear in early January. These two cases are not Second Amendment lawsuits, so I want to be clear with that, but they do have huge implications for two-way litigation and also what the ATF is currently doing with their overreach. These cases can help stop the ATF's pistol brace rule, their bump stock ban, their frames and receivers rule, their private party transaction rule, their attacks on FRTs, suppressors, SBRs, and a lot of other items that the ATF currently regulates. These cases are Loper Bright Enterprises versus Raymondo, and then also Relentless Inc. versus the U.S. Department of Commerce. These cases aim to use issues over fishing to bring an end to Chevron deference for good. Now, the facts surrounding this issue in these cases are similar in both the Loper and Relentless case. Relentless Inc. is a fishing company that operates in New England. The company is engaged in herring fishing along with other fishing that they do as well on their boats. Relentless fishing in their boats are a little bit different from the Loper case and the Loper boats because in fact the Relentless boats are larger boats and often they take trips that are 7 to 14 days at sea. This is different from the smaller herring boats that many of which only go out for about 2 to 3 days at a time. However, here the issue is that the herring industry in the area came under attack because of the National Oceanic and Atmospheric Administration, which implemented a final rule in 2020 which forced fishing companies like Relentless and Loper to pay for a human at-sea monitor that had to be on their ships. Not only does this monitor take up space on their boats, but the fishermen must also pay that monitor's salary, which is estimated to be around $700 per day. This new rule caused some of the fishing trips to cost actually more money than they made when they were out fishing because they had to pay the monitor $700 per day, and they wouldn't actually recoup those costs from what they were doing as far as fishing. And if the fishing boats declined to carry that monitor and that person on board, well then they were prohibited under the rule from actually even being able to fish. So they were in a bad place and they had to have these monitors that cost them more money. Now originally in a different case, a smaller company called Loper Bright Enterprises and other fisheries sued to challenge this rule, arguing that the agency lacked statutory authority to force them to pay for these monitors who had to be on board. On review, a district court held that the statutory text did authorize this new rule for the monitors. Loper Bright then appealed and a DC circuit held that the statute was ambiguous, but then the court deferred to the agency's interpretation under the doctrine of Chevron deference. Loper then filed this petition to the U.S. Supreme Court for review, and the Supreme Court recently granted review to the Loper case, setting the question for review to be whether the court should overrule Chevron or at least clarify that statutory silence concerning controversial powers, expressly but not narrowly granted elsewhere in the statute, does not constitute an ambiguity requiring deference to the agency. This case, Relentless, was similar and has a similar background. The rule was challenged and the rule was upheld in the First Circuit Court of Appeals. The court found that broad, necessary, and appropriate language in the statute gave this agency the power to mandate those in-person monitors. Now, in reaching that conclusion, the First Circuit relied heavily on Chevron deference to uphold that agency's interpretation and what they claimed was an ambiguous statute. Relentless Enterprises also sought Supreme Court review of that decision and received an order that Supreme Court did grant review of this case, and then they consolidated it with the Loper Bright case. So they're going to be heard together on January 17th. So the Supreme Court will hear two cases on January 17th and will decide whether or not they want to overrule Chevron deference altogether, or at the very least, greatly limit the ability of agencies like the ATF to use Chevron deference when a statute is silent on a very specific issue. Now, if you're not aware of what Chevron deference refers to or what's at stake in these cases, let me explain. Chevron deference is a term coined after a landmark Supreme Court case, which is the Chevron versus the Natural Resources Defense Council case. This case established the concept of courts upholding an agency interpretation of an ambiguous statute or term that Congress has tasked that agency with implementing. However, generally for an agency to be given Chevron deference, the agency's interpretation of that ambiguous statute must be rational or reasonable. When a statute is ambiguous in some way, the agency responsible for enforcing that statute may be able to determine what Congress intended as long as their interpretation is deemed rational or reasonable. Now, in contrast to Chevron deference, there are other concepts that are sometimes used. For example, there is something known as the rule of lenity, and the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear, or ambiguous statute in a way that is most favorable to the people, not the enforcement agency. There is also another concept called the major question doctrine, which the Supreme Court recently used in a different case called the West Virginia v. EPA case. And then they also used it in the current student loan decision that they issued this year. And under the major question doctrine, the Supreme Court declared that if an agency seeks to decide an issue of major national significance, its action must be supported by clear statutory authorization. What the Supreme Court indicated in West Virginia is that agencies will no longer be afforded broad Chevron deference when their actions have vast economic and political significance. Instead, the court is now establishing that if Congress wants to give an administrative agency the power to make these types of decisions, it must state that fact very clearly and expressly in the statute. Now, despite those recent decisions, there has not been a complete doing away with Chevron deference, but there is a lot of interest by the Supreme Court and a lot of justices on the Supreme Court to want to do away with Chevron deference completely. And in these new cases, it appears that the Supreme Court is in fact going to take up this very issue, and it seems like there may be an end to Chevron deference going forward. They will now decide if they want to completely do away with Chevron or at least put significant handcuffs on it and pretty much limit agencies like the ATF and others using Chevron deference to justify their overreach in the restrictions. And this is significant because the ATF uses Chevron deference a lot and has used it a lot in the past, especially in litigation, to justify their restrictions on various items and also their overreach and their restrictions against the Second Amendment. For example, in just the last 5 years, the ATF through rulemaking has issued a rule banning bump stocks, since they now claim that those items are machine guns in their own right. They also put in place rules and restrictions on polymer 80s and unfinished frames and receivers. And again, that issue is currently being litigated as well. They put restrictions on braced pistols, treating them as SBRs under the NFA. And this is all being done through the ATF claiming that they have broad statutory authority given to them under the NFA and GCA. If Chevron is completely done away with, then the ATF's claims that they have this type of authority will no longer be valid. And a lot of people in the Second Amendment community know this. You've had multiple organizations that have now jumped in and support these cases, to support Loper Bright and also the Relentless Inc. Companies that are suing their agencies. You've had organizations like FBC and GOA already file amicus briefs in support of the Loper case, and I believe also the Relentless case, seeking for the Supreme Court to also strike down Chevron deference. But of course, the 2A organizations are more interested in restricting the ATF, dealing with a different agency, but they are still supporting the restriction of Chevron. Now, one thing I also want to point out with this topic is that recently the ATF, in some of their litigation, is trying to, in fact, move away from heavily using Chevron as their main claim for authority and their main support for these rules that they're putting in place. Instead, they have started to argue that the text of either the NFA or GCA expressly gives them the ability to do these types of actions. For example, with the bump stocks, the ATF claimed that the term machine gun now is very clear. They claim that it's a clear statutory text and term that does in fact include items like bump stocks. So instead of just leaning completely on Chevron, they first start to argue that the clear text supports their argument. And then later in their arguments, they will say, well, even if the term is ambiguous, well, then we still win under Chevron. Before, they would just completely rely heavily on Chevron, but now they're being a little bit more nuanced in their arguments because they know that Chevron is probably going to be done with very soon, so they do not want to rely exclusively on that argument. So for a while now, the ATF has known that Chevron and those types of arguments are likely going to be on life support going forward, but the Relentless and Loper case decisions will go a long way to ensure that courts will no longer just defer to whatever the ATF says, and again, could have huge ramifications going forward. And also the combination of these cases, some of the prior case decisions with the West Virginia cases, and then also the potential of the Cargill bump stock lawsuit going our way could do a lot to actually restrict the ATF going forward and stop a lot of these actions. So like I said, although these cases do not deal directly with 2A issues, it does deal with a major legal principle that has been used against us in these 2A cases. I will be listening to the arguments that happen on January 17th. I will also make sure I link those if you guys want to listen to them yourselves. Maybe we can do a live stream or something. If you're interested, let me know in the comment section. But again, Chevron deference could be ended and could be greatly restricted coming forward in 2024, which would be a significant win for the 2A cause. So if we get any more information, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.